planning regulations with 3D Cadastre. The presentation will be done by Saeid, and Saeid is PhD student at the Geometric Science at University of Laval. Saeid, the screen is yours.
Thank you, Dr. Roich. I will share my screen and then I start my presentation. Can you see it now?
Yeah, looks good. Right, it's clear.
It's clear? Okay, I will start my presentation. Hello, everyone. My name is Saeid Emamgholian, and I'm a last year PhD student in geomatics at Laval University, working under supervision of Professor Pouliot from Laval University and also Dr. Shojaei from the University of Melbourne. Today, I'm going to give a presentation entitled 3D Zoning, a Missing Piece to Link Planning Regulations with 3D Cadastre. My PhD research project has started in 2019 with a focus on modeling land use regulations as part of 3D city models, and consequently detecting potential conflicts among physical and administrative objects. And during these years, we were always discussing the necessity of considering these restricted spaces caused by planning regulations in cadastral systems, which is the main point that we are going to talk about it today. Let's start this discussion with the first question, which is such restrictions, should they be represented within 3D Cadastre? The fact is a 3D Cadastre that presents rights, responsibilities, and restrictions should also represent usable and restricted spaces caused by planning regulations. If not, everyone can consider the ownership of land parcels and their properties from the center of the earth up to the sky. But there are some restrictions that make a land parcel to be developed only on a specific space that we call it today usable space. We think we can link planning restrictions with 3D Cadastre so that we can get one step closer to have a larger land use information system called multi-purpose cadastre that is not a new concept in this domain. And in such a system, not only cadastral purposes, but also others like planning purposes can be integrated. But how? Today, we want to open a discussion on how to make this linkage happen. And to answer to this question, we have a suggestion. We think 3D zoning with the capability of representing planning restrictions in 3D is the missing piece that as the first step for moving in this direction can make this linkage happen. It has a great potential to enable representing restricted planning spaces for 3D cadastral purposes in a more visual way. But in addition to visualization, it can also be integrated with the process of checking the compliance of land developments. To this purpose, enriching 3D zoning with a 3D representation of planning restrictions can facilitate identification, also validation and registration of RRRs. Now it's good to know about zoning. What is zoning? In urban planning, zoning is a regulatory mechanism that divides land parcels into areas called zones, in which a set of restrictions controls uses and developments on land. And the main purpose is orderly urban growth and development. Generally, it includes a color-coded system in which clicking on a city zone will bring up general information about that zone. Based on this information, related planning restrictions should be found in primary and secondary sources such as regulatory documents. And because of the complexity and multidimensionality of planning restrictions, identifying their extents as well as potential conflicts that may arise is not an easy task and requires lots of expertise and analytical skills, especially when 3D components are involved. What about 3D zoning? Do we have a 3D zoning? It exists. Several software development companies and cities are launching their first version of 3D zoning containing a 3D representation of some planning restrictions such as height and setbacks limit. However, in addition to not being fully operational and accessible, it's not fully enriched, and also its linkage with 3D cadastral purposes is still lacking. Now, there is another important question to answer, which is, can we map all planning restricted spaces into 3D cadastre? This time the answer is no. It's not that straightforward. The main reason is, as mentioned before, 3D zoning is formed by planning zones and mainly includes planning information. Moreover, planning restrictions are not necessarily fully representable in legal environments such as 3D cadastre is. So the first step, we need to review planning restrictions and identify the potential ones that can be added to 3D zoning and be integrated with 3D cadastre. And to be more precise in our presentation and in our discussion today, we have, and to have some concrete examples, from now on, we will focus on planning restrictions subject to planning approval in the state of Victoria, Australia. To identify potential planning restrictions, we proposed 3 groups of planning restrictions. The main distinction between these groups is whether physical objects are required either in the new development proposal or in surrounding buildings or city furniture to map or represent these restrictions into 3D zoning. The first 2 groups that I've listed some examples here include those for which the design of the proposed development or surrounding buildings and city furniture are required. So they cannot be mapped into 3D zoning unless we have access to the design model of the proposed development or 3D city models, including existing buildings and city furniture. For example, for mapping overlooking into 3D zoning, we need to have access to the window of proposed development. And as another example, in second group, depth limitation requires some underground asset like sewer pipes in 3D city models. But the last group includes planning restrictions that can be mapped into 3D zoning, mostly based on planning information. And it seems to be the most valuable one to achieve the overall objective as starting to enrich 3D zoning and integrating it with 3D cadastre to enable visualizing restricted and usable spaces. To support our discussion, I present an example by selecting a land parcel in Fisherman's Bend area in Victoria, Australia. And to start, imagine that a multi-owned development is going to be constructed on this land parcel. No matter you are an owner of this land parcel or a developer, builder, land surveyor, an architect, or even a citizen who lives in this neighborhood in adjoining buildings, we are all in the same boat. We all want to know where these restricted spaces are exactly located and to what extent this land parcel can be developed. For this example, we will use Cesium.js, a web-based application that uses JavaScript, and it includes 5 planning restrictions in the 3D zoning group, which are height limits, side and rear setbacks, street setbacks, noise impacts, and flooding limits. Based on the location of the land parcel and its assigned planning regulations extracted from the planning scheme ordinance and complementary documents and guidelines, a height limit of 36 meters and 300 meters distance from the nearest lane of the closest freeways applies to this land parcel. It is allowed to have a street wall with 8 stories height for its front street and 6 stories height for its side street. From that level up to the height limits, 5 meter setbacks applies to front and side streets. Also, 5 meters side and rear setbacks must be applied to both side and rear boundaries. And finally, based on the location of this land parcel, 2.4 meters flooding limits should be considered for this land parcel. By considering all these explanations, this figure illustrates the restricted planning spaces applicable to the selected land parcel. And accordingly, usable spaces can be specified for development on this land parcel. Usable spaces here refer to spaces that are not restricted by planning restrictions, as you can see, and it can be used for developments on this land parcel. Today, I discussed that 3D zoning as the missing piece can be enriched with the representation of restricted planning spaces for all parties. It's good to know that in some jurisdictions, like in Victoria, verifying cadastral plans with such restrictions is not reachable unless surveyors lodge an application for the proposed development to the responsible authority. So the enriched 3D zoning can be used by architects for designing proposed development, by land surveyors, for example, when defining new ownership boundaries, and even by planning authority for verifying proposed development. It can also enable having a multi-purpose cadastre to find better compliance between land use, urban planning, and citizen welfare. Since planning regulations can contain discretionary or mandatory rules, restricted spaces in the 3D zoning do not necessarily mean that they are not usable. This aspect reminds the importance of having a qualitative reasoning in a later stage. Although the general planning rules may be the same, it's not straightforward to achieve a generic approach that maps all the limited spaces. And we should be aware of the differences in the description of rules. The required data like planning information, zoning base map, and related guidelines are provided by different organizations with different level of accessibility. To achieve having an integrated land use information system, including all required data integration challenges like data quality and standardization should be considered. And as the first step, we only had one group, namely 3D zoning group, that could be mapped into 3D zoning. To represent all restricted spaces, we should consider that 3D city models should also be integrated with the enriched 3D zoning in later stages. I'd like to thank everyone who has helped and supported me in this project, and I appreciate your time, and if there are any questions, I'd be happy to answer. Thank you.
Thank you. Thank you, Saeid. We have question here, only one, unfortunately, but there are questions. There are now more questions. The first question for you is, did you consider using a new LADM Part 5 spatial plan, zone information? That's a PhD thesis von Agung in Right with example from Jakarta and Bandung.
That's a good question. Actually, it's not only related to LADM. It's this part. We are working on that. Also, we are keeping an eye on other available like CityGML and also CityJSON to represent and integrate such information with those standards. But the main point here is there are two aspects that we should consider for that part. First is these planning restrictions are part of legal and restricted spaces, not physical objects. And also the modeling part. Actually, I'm going to have a presentation on modeling aspects of regulation shortly in 3D GeoInfo conference, but they are not easily representable as a volumetric objects in LADM or other available standards. That's the main points that we should consider for this question.
Thank you. And another question is, did you try visualizing underground 3D zones for end users?
Actually, it can be done for underground too, but for this research, no. We had a list of regulation, as mentioned. Those regulations that are not related to physical objects, for representing them, we don't need physical objects, but were the main focus of this study. But it's quite possible if we, for example, have access to underground assets, we can also consider the representation of restrictions for underground objects.
There one more question, relatively similar to question before. Do you consider modeling the restrictions from 3D zoning in the context of LADM edition 1 or edition 2, either as generic restrictions in LADM part 2 or specific ones in LADM part 5?
Actually, these aspects are really important, and I understand why I'm receiving a question related to LADM and linking between restrictions and standardization. But as I mentioned, there are still some challenges that if we want to go in this direction, we need also take into account that for modeling and representing these restrictions as a volumetric objects, it should be, for example, I think it should be an extent of these available standards. And for now, I believe that there are some challenges that still need some further work. That actually it's part of upcoming work of this research field. But for now, that's the main important points that I think I should mention for having those restrictions in LADM or other available standards.
Mm-hmm. And we have continuation from the previous question. This refers only to the legal spaces of those restrictions. The physicals could be implemented in multiple formats, GeoJSON, and so on.
That's a good question, Eftychia. But as I mentioned, some of these planning restrictions are linked with physical objects. You cannot distinguish them from each other. That should be considered in one platform. If we are going, for example, saying that some of them are not related to planning physical objects, as you mentioned, but we cannot say that we don't need physical objects for them, because in a later stage, we want to know, for example, if there is a height limits here, where are the physical objects that do not respect this height limit? That's the main point that I'm trying to mention, that if we want to go in this direction, we need to have a solution outside of these standards and try to integrate it. That's my suggestion for now. But I think we can work on that part. And in this presentation, I didn't aim to discuss those aspects, but it's a good question and good challenge to address in near future.
Now we are up to time, and I will make only one question more. This discussion about LADM and so on can be discussed after the session of the.
Sure.
This is a long. This can be long discussion.
Yes, exactly.
Only short question: which LOD do you recommend for 3D zoning?
That's a good question. If we want to consider integrating 3D city models with 3D zoning, as I suggested in last slide, I suggest that you join me in my presentation in 3D GeoInfo conference shortly. At that presentation, I will discuss that we need a multi-LOD system, not only LOD, but level of information, because LOD do not necessarily guarantee that integrating and enriching 3D zoning with restricted spaces is quite possible. That's the main point that we need to discuss it. But for some planning regulations, we need LOD1, for some LOD2, for some LOD3, and even for some, we don't need 3D city models with LOD or something like that. That's a question that we don't have one answer to this question. For some of them, it can be it can be possible with LOD1, but for some others, like for example, I can say overlooking, we need LOD3, and that's a question that we should consider. We need multiple LOD for representing these spaces.
Okay, thank you once more for the nice presentation and interesting discussion. And we are going further to the next presentation. Is organizational rights and responsibilities in complex 3D real property developments, the relevance of bridging research fields. The presentation is from Morten. Morten is a PhD candidate at Aalborg University. Please, Morten, the screen is yours.
Thank you very much. Well, hello, everyone. My name is Morten Madsen, and I'm here to present the results from my PhD project on 3D properties in Denmark. The supervisors on this project is Jesper Paasch and Esben M. Sorensen. And this particular paper is about organization of rights and responsibilities in complex 3D property developments, opposed to simple 3D real property developments. And I'll try to explain the difference later. I'm an industrial PhD student and a chartered surveyor. And as an industrial PhD, I use 50% of my working hours as a chartered surveyor with hands-on assignments, and 50% I use at the Institute of Planning at Aalborg University. Now, this constellation of an industrial PhD provides a special look into the real-world practice of forming 3D property situations in Denmark. So it provides the insight and the expert knowledge regarding the practical solutions used to form 3D property. And this has been very important in order to find the direction and focus of this PhD. So one of the main purposes of this PhD is to answer the question why Denmark, that is considered one of the most digital societies in the world, has not taken any scientific or political steps toward a more modern 3D cadastre. We still use the traditional two-dimensional solutions, and there's nothing expected on the way. And we believe that we can partly answer this by this survey, which is based on some classic legal American condominium publications and publications of the more modern Swedish property 3D system, and a case study which I've conducted of the Danish practice. So based on this, we propose that there is general at least two different systems that has evolved as the building structures in cities has become more mixed in use and complex over the last couple of decades. We have one system that is the traditional condominium system, and then we have another system that is the more modern 3D property system, such as the one we find in Sweden. So the intention of this paper is to discuss these two different 3D property systems. So a traditional condominium system, such as the one we have in Denmark and in the United States, was introduced in the 60s with the main purpose to facilitate the possibility to form owner apartments in housing. But at the same time, it was open for other types of use, like in the Danish and the United States condominium legislation. Now, it's interesting to see that these two systems have evolved differently. The system in Denmark is actually still in its original form, but in the United States, it was necessary to change the legislation into a second generation legislation in the late 70s, because they needed a legislation that was more capable of dealing with the more complex situations where building included a mix of different use. So I think we believe that it's fair to talk about simple and complex condominium developments. The simple condominium developments was the ones that the condominium legislation from that period was designed to handle. And we're talking about traditional staircase apartment buildings with only one type of use, or maybe a shop in the ground floor. Whereas the complex is more for the multi-purpose buildings, where in these condominium properties, you always have a common property consisting of some parts of the building and the ground and the roof, and you need to organize who has the responsibility. And in these simple cases, it's quite easy, because all condominium units, they have almost the same benefits of the common components. And in the complex case, you have situations where condominiums with different use have different use of the common components. So the complex condominium development, such as building with a mix of commercial and housing condominiums, you have a need to split this common property of different facilities or parts of the building, because each condominium do not have the same benefits. So you have to disrupt, or you have to reorganize the standard principles of the condominium law, that all condominiums, they have a share in the common property. Now, in the classic condominium literature, this is often addressed as splitting the common property into a two-tier governance structure. For instance, to make each use type independent, so that all common facilities that only benefit one part of the use in a building, for instance, the commercial condominiums, they are separated from the condominiums used for housing that has no benefit of those common components. And moving to the other system that we have seen has developed, we have the 3D independent property system in Denmark, or 3D independent property type in Sweden. Excuse me. And in Sweden, there's no long history of a condominium legislation, so you have no tradition for using condominiums for different kind of use and organizing the relationship between those types of condominiums. So when the market demanded this new, this 3D, the possibility to form 3D property, new legislation was drafted that was probably more fit to handle the situation. And that led to the solution of the independent 3D property that was implemented in Sweden in 2004, and also another 3D property space, but I will not go into details about that one. You can read more about that in the paper. The important thing is to understand the 3D property specifications. And also in 2009, there was another 3D property implemented, which was the condominium property. This is very different from the traditional condominium system. This condominium type can only be used for housing purposes. So all these 3D property types in the Swedish case can be mixed in the same building. So comparing the traditional condominium system and this more modern 3D independent system in Sweden, if you see the building on the slide, if we take the Danish system, you will have each part of the building to be one type of condominium, whereas in the Swedish case, you will have an independent property in the street level, the shops, and then in the mid layer, you will have another independent 3D property, and then you will probably have the condominium property in the top floors. So you have the same situation regardless if it is the 3D property system from Sweden or the condominium traditional system in Denmark, that you have to organize the relationship between these different types of use. So in that sense, there is not much difference from the Swedish, the Danish, or the American classical situation. So in Sweden, forming the common property and facilities is part of the cadastral procedure, whereas in Denmark, the standard from the traditional condominium system is that unless you make any disruption or you reorganize and split the common property into a two-tier governance structure, every part of the building will have the same benefit of and the responsibility to the common components, and that's not an optimal solution. So we have both the Danish traditional condominium system and the Swedish 3D property system, and they both create 3D property. So we argue that they both equally can create secure property boundaries in 3 dimensions to support the market demands, but the Swedish property system is rooted in the legislation, which is fairly new, whereas the Danish, to a large extent, rests on law practice. It rests on a legislation that is not developed to support the market demands. So the Swedish system is probably more flexible than the Danish, but the legal situation is probably the same. So you can say that the Danish condominium system in many ways was not designed to handle the situations that we see in the marketplace today, but it actually still works without any complaints. And why I think one of the reasons is probably that there's no indication that the cost of organizing the relationship between different types of views in a building are better or less expensive in a modern 3D property system such as the Swedish compared with the Danish condominium system. And one of our points is actually that the Achilles heel of forming a complex 3D property is more related to the organization of rights and responsibilities between the property owners. And because this is working in practice in Denmark, that might be the reason that no steps has been made towards a more modern 3D cadastre like the one we see in Sweden. So as long as there's a legal security and everyone is satisfied, nothing seems to happen in order to move towards a more modern 3D cadastre. So to sum up our points, one of the purposes with this presentation is to show that the paper that the condominium literature is rich on organizational issues, legal issues, and the 3D cadastre research, as we have identified, is rich on the more aspects of registration, modeling, and technical aspects. So we believe that if both research fields bridge, they could benefit of learning from each other. So based on this situation that we see in Denmark and Sweden and partly the United States, we believe that systems with a long history of condominium practice, as we see in Denmark, and changes in legislation, condominium legislations, to be adopted to a more to the more complex building structures that has evolved, like we see in the United States. Such systems will hesitate to implement a 3D property solution such as we see in the Swedish, because the condominium legislation or practice has mutated and adopted to the more complex building structures over history. And opposite that, we have in Sweden that there's no long history of condominium ownership. So instead, it was necessary to implement a new 3D property legislation. So that was our main point, and what we wanted to open for discussion with this paper and this presentation. And at the end, I would like to use this opportunity to recommend an online PhD course, Urban Design with 3D Cadastre and Property Rights at Aalborg University next month. So please contact Esben Sorensen to sign up for this if you're interested. Thank you very much.
Thank you, Morten, for the nice presentation. We are going now to the questions. I see here a few questions. Is land a component of 3D property in Denmark and Sweden?
Yes, land is a component of 3D property in Denmark, but it is difficult to talk about 3D property without having land in mind. But when we talk about this traditional condominium system, it's only in terms of buildings, because you cannot form a condominium without a building. So the 3D property system regarding land is another story, where we use in Denmark the traditional solutions, mostly use rights to form a 3D situation, but we cannot in the cadastre form a real property in 3 dimensions in land. And yeah, I hope that was an answer to the question.
Okay. In Netherlands, they have situation with complex apartment, condo rights, where both legal experts and surveyors cannot clearly see what is the ownership situation. Did you see similar cases in Denmark?
No.
No.
Oh.
Maybe
It's
maybe-
some. Not
maybe
not
clarify the
regarding
question.
the condominium property itself, the real property, but sometimes property rights over the common components of the condominium property can be a little bit difficult to define who has the right to use, and sometimes at the end it's up to the court to decide. But
What I wanted to ask and what was not clear is the experts could not see it from the documentation. So from the deeds submitted and the cadastral maps, they could only see it, and it was clear if they go into the field. And
okay, yeah, no, we don't have that situation in Denmark. Where in terms of the condominium, it's very well documented. Always as built surveying by a chartered surveyor and registered. So it's condominiums in Denmark are very well documented. Yeah, and that's also why we have no problems.
Are they in 3D documented?
No, they are mostly paper based. Actually, we have modified the registration system. So that's another story, but the registration of condominiums was a couple of years ago, from 1966 until 2019, at the land registry. But it has been moved to the cadastral, to the cadastre now. So when you register a new building, you have to register a GML file as well with the property boundaries of each condominium. Yeah.
Okay, good.
But so you have two registers. You have the land registry, where you have to see the old condominium boundaries, and then you have the new boundaries at the cadastre. So it can be a bit complicated.
And if there are differences in interpretation of the property in land registry and cadastre of the same property, what is the legal precedence if you have differences in the registration of the same property?
Yeah, well, in theory, it's not possible to end up in that situation, because every time that there is a new formation or a change in an existing condominium property, it has to be registered, of course, with the cadastral authority. But every time the land registry has to approve the change, so they will check that with their own system and the registration. So up till now,
okay, thank you. I understand. There are quality control from the land registry in advance. Yeah. One more question. Are there any differences in condominium legislation of the application of legislation between US states? Are you familiar with US states legislation?
Yeah. I'm not sure I understand the question. Maybe
Jesper is here. Can you clear your question?
Can you unmute, Jesper? And
Morten.
Hello. Hey, Jesper.
A very good presentation. But I just want to ask, have you seen any differences in the use of the US legislation, like how they do in Florida or California or other states?
Oh yeah. Well, in 1978, the adoption of a second generation condominium legislation was called the Uniform condominium legislation. So it was meant to be used in all the United States, but they do, and they are modified to fit each state. They can, yeah. So
okay,
short
thank
answer,
you.
yes, there are different applications of the legislations. Yeah.
Thank you,
We
Morten.
have one more questions. Have time for this one. Are there any provisions, thoughts for 3D property in Denmark regarding other types of real property objects such infrastructure or utilities?
Yeah, but it's
or
yeah, you have a register for the for pipelines, and I don't know if that can answer the question, but yeah, that's there is a registry for some of the infrastructure, and you have a separate registry for public roads, and yeah.
Okay, it's solved by special external registries.
Yeah. So when so this is mainly real property.
Okay, thank you, Morten, once more for the nice presentation and answers on the questions. And we are going to the next presentations. That is modeling 3D legal spaces of public law restrictions with the context of LADM revision. And presentation is from Dimitrios. Dimitrios is engineer and works at National Technical University in Athens. The floor is...
Thank you, Professor Roy. Let me share. Just a moment. So, can you see my screen?
We see the presenter mode.
Oh, just a moment then. Wrong screen. So, try again. Sorry.
Yeah.
Very well.
It's okay.
Yeah.
Today I will be presenting our joint work with Eftychia Kalogianni and Professors Efi Dimopoulou, Jaap, Zevenbergen, and Peter van Oosterom on modeling 3D legal spaces of restrictions deriving from public law within the context of the LADM revision. Actually, this is a work that has started a couple of years ago for the first version, for the first edition of LADM, and now tries to follow the updates and the revision of the LADM for its second edition. So the motivation for this work starts from the gradual increase of public law restrictions for PLRs, especially in number and complexity, and their concomitant legal and technical challenges regarding their registration. Moreover, research on the management of public law restrictions, especially in the field, especially within the context of 3D land administration systems, limited. And of course, it was a great opportunity, the revision process, the ongoing revision of the LADM for its second edition. PLRs can be modeled within the second edition of the model. The aim of this work is to propose a flexible model public law restrictions at a conceptual level in the context of LADM edition 2 to classify public law restrictions, investigate different alternatives on their organization and modeling, and we validated the modeling proposals using 2 case studies in Greece. So a few works about PLRs, about public law restrictions. First of all, they are restrictions imposed by the state on individuals. This means that they are of obligatory character. This distinguishes them from private law, in which when there is a mutual agreement between the involved parties, other law is infringed, they are subject to change. Public law restrictions also derive from multiple legal statutes of different scientific fields. This means that they cannot be traced in one place, in one registry, and they are usually not related to land law, actually. Moreover, they are descriptively defined with references ranging from pure references to 3D characteristics, which is actually not the most usual case, to more abstract definitions, for example, to physical or other types of characteristics, which means that all these references need somehow to be translated to spatial terms, to volume, depth, or height. Moreover, can be parcel-based, or in most cases non-parcel-based, so they are independent from cadastral parcels, and as already mentioned, they can be registered in various registries. So from the above, I think that it is clear pose significant complexities on land administration and land exploitation. They require time-consuming research so that to identify which PLRs apply to a specific part of land and to what extent of this part of land. And of course, this may lead to delays and not only investments, but land exploitation as a whole. So here you can see some indicative cases of public restrictions with, for example, construction regulations or heritage protection. There are many others, of course. And if you think that we could public restrictions by moving to rural environment, this is unfortunately not the case. We do have several public restrictions applying also in the rural environment. So this means that public restrictions need to be systematically organized and to be registered so that we avoid ambiguities and that we represent clearly the legal status of that applies on in the context of rights, restrictions, and responsibilities. So when it comes to organization, of course, of standardization, and when standardization is combined with land administration, then we can directly think of LADM, of the land administration domain model. So the evolution of the model from its starting point in 2002 to its first milestone in 2012 when it became international, with numerous implementation and industry solutions and LADM-based country profiles developed during these years. Now the model is under revision. We do have a model will comprise of first one has been already been voted positively by the ISO. And we do have two other parts that have been already been submitted for review, for revision. So public law restrictions fall into the second edition 2 of LADM. So in this work, we have tried to classify public law restrictions and organize them based on the second part, as I've already mentioned, of the edition 2 of LADM, based on taking into account two criteria, as you can see on the slide. The first one if PLR should be modeled at the legal part of the LADM or at the spatial part. And the second one, if subclasses should be used to organize the various PLR categories or a structure with semantically enriched code lists with hierarchical structure. So as regarding to the classification, we were based mainly to the Greek legal framework, identifying and classifying public law restrictions to 8 different sectors. Actually, we can see only 5 of them due to space purposes on the slide. These comprise of mining areas, cultural heritage, building regulations and spatial planning, civil aviation, environment protection, and another field that you cannot see, major infrastructures, military zones, and public utilities. Each of these, of course, comprises of subcategories of more PLRs. We have tried actually an extent thematic classification of public law restrictions, refining our proposed classification in our previous work. Coming to the modeling of public law restrictions, here we do have 2 different options, modeling at the spatial part and the part, as already mentioned. Modeling at the spatial part, as regarding to the modeling at the spatial part, we do have two different alternatives. You can see the first one, as presented a couple of years ago, with LA level concept enriched with code list values of the LA restriction. You can see them on the slide, and the inclusion of corresponding rights levels. You may note that we do have more than the 8 presented classified public law restrictions. This is because this was our first proposal, as it has been structured 2 years ago. So, going to our second alternative, this is in this case we introduce a new class, the LA public law restriction class, that is associated with the LA spatial unit class. And the new code list is based on the classification of PLRs, as you may see on the right of your screen, using a hierarchical code list structure. We also use the attribute external PLR to link individual PLR registries with this alternative, with our modeling approach. Next, we look at the legal part option. In this case, classes that the LA restriction class, the private and the public law classes, and the public law restriction class needs 8 more subclasses according to our classification to the categories already mentioned. So, trying to briefly summarize our alternatives, our options and the different alternatives, modeling at the spatial parts using the LA level concept allows for flexible and discrete modeling of information, modeling both rights and restrictions that are related to PLRs. Our second alternative shows that simple modeling, as only one class needs to be added, including generic characteristics applying to most of the PLR types, but it is not very flexible, as it needs to add further information, as it needs to be related to different to other registries. The legal part provides a discrete and clear model of the various characteristics of the categories of PLRs. However, it is due to the need of introducing multiple new classes for each type of for each PLR. So, to evaluate our proposals, we have used 2 use cases. The first one is restrictions imposed due to the crossing of the Trans-Adriatic pipeline in land parcels. The Trans-Adriatic pipeline crosses the northern Greece, and there are 3 types of restriction zones established during its route. The first one, 4 meters along its center line, imposing construction and agricultural restrictions. The second one, 20 meters along the pipeline center line, imposing construction restrictions and imposing restrictions also to the activities altering ground's morphology. And the third one, 400 meters along the pipeline center line, imposing restrictions to the number of buildings that can be constructed. Actually, this mainly refers to future constructions. So, all these restrictions can be modeled in this instance diagram. As you may see, the spatial unit related to the different restrictions and the attributes as coming as specifications of each restriction zones. Next, we do have restrictions related to archaeological protection, the protection of the archaeological site of Vundeni, which is located in the municipality of Patras in western Greece. So in this case, we do have 2 different zones, one where only agricultural activities are allowed, and the second one where specific regulations regarding the construction of buildings are imposed. So again, here we model at the legal part of the LADM. So you can see how the instance level diagram of this case with the introduction of the public law restriction class and its relation to the cultural heritage subclass and the restrictions imposed by the different administrative documents. So To conclude, in this work, we took advantage of the ongoing process of the LADM revision to initiate discussion on developing a generic model for modeling public law restrictions. And we have tried to identify the advantages and the drawbacks of different alternatives. From the examined case studies, we can note that the legal approach is more efficient when PLRs have different characteristics to be modeled as different attributes, while the examined alternatives on the spatial parts show more emphasis on the spatial extent of public law restrictions, leaving the legal aspect presented in the form of code lists or attributes. We think that the ground is not yet mature to propose a single solution for modeling public law restrictions, which, however, can be addressed with, of course, further research. This may refer to extending to other types of public law restrictions, to examining different legal approaches among different jurisdictions or among different legal families within the same jurisdiction, and of course, identification of different best practices and drawbacks. So with this, I would like to conclude this presentation. Thank you very much for your attention.
Thank you, Dimitrios. Presentation, and unfortunately, I don't see question. Yes, now we have one.
Great.
What is minimum parcel depth?
Well, would you like a specific definition of the minimum parcel depth within the Greek legal framework, or is it something more specific?
Yaroslav is here. He will precise this question.
Actually, I have no clue. I've got some suggestion what it is, but for me, parcel is like inspired 2D. But what is more or less in your case? Is it a 3D parcel or something like this?
Well, actually, we do have the land parcel in Greece follows the superficie, the Roman maxims, so it extends from the center of the earth to the skies above. Of course, this does not apply. We do have, in case of traditional cases of traditional constructions for buildings, for example, it is considered that it is the maximum space, the maximum depth that the construction is allowed to be made according to the building regulations. In case that we do have major infrastructures, then we do have these are considered to be of public benefit. So we do have so they can be constructed below. Of course, if the construction of the above and imposing restrictions to the above parcels in terms of buildings and so on.
Okay, there are more. Will be there any example for physical database implementation of the concept?
Well, of course, this is a work in progress. We are looking for new ideas. We are only at the start of this research. Public law restrictions is a huge topic and has many different aspects, technical, legal. So, of course, it is something that needs to be examined as well. Yes.
Okay. And why do you think that public law restrictions shall be included in LADM edition 2, part 2? What is the added value to model them at an ISO standard?
Well, actually, it is what I've mentioned at my first on my first slides, that public law restrictions affect significantly land exploitation, and they may delay or even jeopardize the development, the construction, or everything. So it is of importance that everybody, not only the public, the professionals, the government, can know where a restriction is imposed, what they can do on their land, and to what extent.
Okay, thank you. And last question. In the top use case, there were 3. LPR instances, their extent must be huge. Or are there more instances?
Well, actually, we refer to the. No, I think that I didn't understand quite well the question. If you would like to clarify, because I understood something that probably is not.
Is for anonymous, and this can be discussed later. Peter is here. Peter.
Okay, I asked it this time anonym because I was co-author. I thought it was funny to ask a question.
Yeah.
So what I meant, as you showed in the instance level diagram of the PLR in the tab, in the Trans-Atlantic pipeline use case, 3 instances of zones. So with different restrictions. But if there are just 3 instances and the pipeline is going from Turkey to Italy,
oh yeah,
it must be big instances.
Yeah, I do understand. Yes. Actually, this needs to be related to the context of modeling utilities as a whole. It is an issue that is discussed and is under research many years now. So we need to also discuss if a utility that crosses from an individual parcel needs to follow the boundaries of the above lying parcel, or it needs to be registered and modeled as a whole. So actually, this is something that is again in need of further research. I'm afraid that I cannot give a direct answer on that.
So they are also not split at, say, for example, province boundary or municipality boundary?
Well, to my opinion, since we are discussing on restrictions that are above the land parcel level, they should be, to my opinion. Of course,
Okay.
research, they need to be huge because it is one single object. But of course, this is open to discussion, and I'm not ready to say that this is it. Could you please unmute?
Okay. I understand your point. I kind of agree. I think I fully agree. We are a team as co-authors.
Peter, do you want to say something? Or okay, I have no.
Are you? Is there any other question or something?
No. Any question? We should go to the next presentation.
Very much.
Is a 3D approach of.
Sorry, Professor Roix, you are muted. You are muted. We cannot hear you. Can you unmute yourself, please? I unmuted you. Dionysia, one moment, sorry.
There's no
Professor
problem.
Roix, you are still muted. I unmute yourself. If you can unmute yourself, I try to do so. If not, please just refresh the page and we will wait for you. Okay. Let's wait one moment and he will be back. I think.
Yeah, there's no problem at all.
You will
No problem at all.
Okay, maybe I suggest that we start with the presentation of Dr. Dionysia Perperidou and Andreas Xydopoulos, named the 3D approach of Greece's property law on urban environmental pollution. And Professor Roig would join us in a while, so I'm stepping out. Dionysia, the floor is yours.
Okay, thank you very much. Good evening, good afternoon, everybody. I am Dionysia-Georgia Perperidou, and I'm going to present the work we'll be carrying out with Andreas Xydopoulos at the University of West Attica regarding a 3D approach of Greece's property law on urban environmental pollution. Oh, sure, I should share my screen, sorry. Completely forgot. Well, actually, urban environment is a complex and multidimensional space, and the urban environmental pollution is one of the biggest problems and challenges that modern societies have to deal with. And we all know that land and ownership and property rights are based in numerous class principles and are subjected to rules and restrictions. And the first rules and restrictions regarding the use of property in respect to health protection were enacted in 1840s in the United Kingdom with Chadwick's Sanitary Act. In the United States, in the 1850s, the nuisance law was enacted when fines were imposed to properties maluse that this maluse was causing damage to community, neighborhood properties, or the neighborhood as a subject. In the early 1930s, the property rights were considered that are in respect of the bundle of rights, which means that property rights is not a standalone definition, but it comes with rules and restrictions and regulations that form this bundle of rights. After the 1950s, and as the urban environment was sprawling, the urban air pollution was affecting a lot of individuals, was causing health problems and property value devaluation. So the first cases of permanent compensation were showed up, especially in the United States of America. After the 2000s, there is an effort to limit urban air pollution, as especially in the EU level, in the Europe, the polluter pays principle is being enacted. After 2010, in order to limit urban pollution and to confront the climate crisis, the sense of building energy consumption to be reduced is enacted. So we are going to more sustainable and greener buildings. Greek property law. The Greek property law was enacted in 1946. It's the Book 3 of Civil Code. Actually, it was launched in 1939, but due to the events of the Second World War, the actual enactment is 1946. In Article 1000, there's a definition that the owner of a thing, an immovable thing, can, as long as there are no conflicts to the law and to the rights of third parties, to use its property, its thing, as it pleases, and to exclude any third party action on it. This is a clear 3D description of what the owner of a thing can do, as the whole Greek property law has legally described 3D objects and 3D situation and 3D conditions. But actually, the Greek property law comes from a centuries-old legal framework derived from the Byzantine Roman law. It's known as Xydopoulos of Harmenopoulos. Xydopoulos includes a series of rules, restrictions, regulations on nuisance, on prevention to fire, in order so as ventilation systems of buildings in big cities around the Byzantine Empire would not be harmful to the neighboring ones. So there are specific rules, restriction, and regulation on private baths, on bakeries, on workshops, etc. And the provisions that were foreseen in Harmenopoulos Xydopoulos had descriptions and regulations that based on 3D conditions and landscape, and all of those rules and regulations are described in 3D. Greek property law environmental protection has many provisions. For example, it has provisions for the protection of the public owned immovable things. Those are exempt from transactions such as beaches, seashores, forests, etc. Has provision so as to protect the surface running waters. Has provisions for rainwater in urban areas so as not to affect neighboring properties. Has also conditions regarding high living condition standards. There are provisions for view easement and non-in-high development is that actually those provisions have affected the building code in Greece, and has provisions on nuisance control, emissions limitation and preventions, and in particular on air emissions, vibrations, intense lightning, and etc. In the project we are carrying out at this moment with Mr. Xydopoulos is focusing on air emissions deriving from urban buildings. So, air emissions are considered as a nuisance that must be tolerant under certain circumstances in urban environment. For example, air emissions from house heating or restaurants must be tolerant if it's in respect of the usual use of the buildings of the area. So this definition on the Greek property law introduces and connects the land uses with how each owner can use his property. There can also be mixed uses as long as those uses do not affect the usual use of the property. For example, a small workshop or a restaurant can exist within a residential area as long as its ventilation system is properly constructed so it does not affect surrounding properties. On the other hand, a factory is not tolerant in an urban area because there is no way that its usual use will not affect the usual use of the residential area buildings. And a small workshop that does not comply with the regulation and the constructions on the regulation, the construction and ventilation system is not tolerant within the urban area that it's developed. And according to Greek property law, the neighborhood property and the neighborhood owner that is affected by this maluse can take action against this maluse. So in respect to the provisions of the property law, certain identification of this air emissions from heating or restaurant ventilations are regulated through the building code, the general building regulations, and in specific for restaurants and for food enterprises from ministerial decision on sanitary regulations and conditions of the food sector. For example, for building ventilation system, there is a very strict legal framework in respect to not create tolerance for the surrounding properties that should be above the building and should be in a distance from the surrounding building. Relevant regulations are applied for the restaurant ventilation systems according to the ministerial decision on the sanitary regulation and conditions for the operation of the food sector. All those regulations deriving either from the property law or from the building codes and how we build in the urban area must be some way incorporated in the Hellenic Cadastre. At this point, the Hellenic Cadastre is organized in spatial level in 2D, but actually it's described, it's the descriptive database describes 3D objects. The legal description in the Hellenic Cadastre follows the legal description of the Greek property law, describes clearly 3D objects. So, how we can incorporate legislation on emissions in the Hellenic Cadastre, which is 2D spatial, 3D in descriptive level. First of all, we can define the property usual use. For example, official acts on land use and spatial planning can be incorporated in the Hellenic Cadastre and can be incorporated in the spatial database. And they can also give us descriptive information. And official regulation on property exploitation and use described in legal documents can also be incorporated in the Hellenic Cadastre spatial database. We can also incorporate it tolerant nuisance descriptions. For example, official legislation on air pollutants limits as a standalone information of the Hellenic Cadastre spatial database, or we can even incorporate it the pollutants dispersion spatial maps, again as a standalone spatial information. And of course, we can consider to incorporate legislation on emissions. For example, we can start considering having information on building permits, which are 2D top use cross-section. We can incorporate them either in the spatial database or at the beginning in the descriptive database. We can also have a connection with official permission authorization on heating and airstream ventilation systems, especially in the descriptive level. And we can have a descriptive definition of the maximum building height that it's permissible either for buildings or either for the ventilation systems. Concluding about this work, on regards of this work, it's obvious that Greek property law foresees specific regulations and restrictions on environmental protection, on emissions, and on nuisance tolerance and control. And actually, those provisions are 3D legally defined, and this is very important. The building code also gives us a set of rules and regulations that it's 2D, but refers also to 3D. And the Hellenic Cadastre, in terms of spatial information, is organized in 3D, but in terms of descriptive information, is describing 3D objects. So we can start considering from moving from 2D to 3D to have an intermediate stage of 2.D Cadastre. Thank you very much for your attention.
Thank you, Dionysia. I hope we can us now. Sorry for any inconvenience.
Yes, Professor. No inconvenience at all.
I was connected, able to switch microphone on to issue of framework. I don't know what.
I understand. There is no problem. There is no problem at all, Professor.
Okay, we have questions. The first is, how does Greek environmental protection law relate to EU directives in same area?
We do incorporate EU directives in our legal framework, but we don't always bring into our legal framework on time, and sometimes during EU controls, they see some deviations from regulation adoption. So we try to adapt EU regulations. For example, there is a huge effort at this moment for the Polluters Pay initiative, especially in the energy sector. We try to shut down the energy factories that combust a lot of carbon, and this is difficult transactions, but yes, we try to incorporate with EU regulations.
Okay, thank you. And another question, do rules for ventilation systems emissions refer to terrain and or weather situation? If so, how can these rules be enforced?
Actually, regulations for ventilation, it's very strict, especially in the case of restaurants. The 3D representation that I show you, it's a reality in many Greek cities. For example, if you have a restaurant in one store building and this building is surrounded by 4 or 6 or 7 story buildings, the chimney has to be higher than the last edge of the tallest building. So it is applicable. In order to get a permit to have a restaurant or to get a permit to build a house, you have to approve that your ventilation systems are applied to the regulation, and there are control bodies from the Ministry of the Environment that actually controlling of the whether a building or a restaurant or a house, it's according to these regulations, and they impose fines.
Okay, there are much literature of 3D Cadastre in Greece and the ongoing project of Hellenic Cadastre. Did you consider it in your research? They are not focused on the environmental field, but related to 3D.
Our research began a little bit differently. We were trying to see, and this is what we're studying at the moment, how a legal document with many spatial and clearly defined 3D objects, because property law in Greece, as well as building regulation or other relevant legislation in Greece in terms of legal defined objects, describe 3D. So we actually, what we did was to see what property law foresees, to analyze what property law foresees, to see what in this case of the environmental pollution and in specific of urban environmental pollution from ventilation system, how the regulations on building deal with this aspect. And then we try to see how we could, in the first stage, incorporate all projects in the Hellenic Cadastre, which actually at the moment is 2D spatially defined, but in many cases 3D legally described. So we didn't start from the Cadastre, we ended up in the Cadastre.
Okay, and the last question, property laws regulate the relations between individuals. Does Greek law regulates environmental issues? Is there overlap with environmental legislation?
Actually, Greek property law, as its legislator, Professor Balis, who was the introducer of Greek property law in 1939, specifically defines that the Greek property law, it doesn't have to do only regarding the relationship between individuals. Balis considers that Greek property law that was enacted in 1946, it was first of all continuance of the Armenopoulos Exapip laws, and it really included restriction and regulations based on the ability of the state to impose states' regulation and restrictions so as to safeguard peace between individuals and to regard a minimum standards in living conditions. And actually, this is very, very vivid in the legislation on emissions and nuisance that has 4 articles describing regulations on emissions.
Okay, thank you, Dionysia.
You're welcome.
Nice presentation. And for the answers on questions, we are going further to the next presentation. The next presentation is toward design and development of a BIM-based 3D property formation process. And the presentation is from Jing San. She is PhD candidate in geodesy at KTH Royal Institute. Please, Jing, the screen is yours.
Yeah, thank you, thank you. So now I will share my screen. Okay, so this is Jingsen, and I'm from the KTH Royal Institute of Technology, Sweden. And today I will introduce our project and present our research towards design and development of a BIM-based 3D property formation process. And this research was supported by FOMAS, a Swedish research council for sustainable development. And as we know, the cadastre contains property unit information and is quite important to provide the efficient, clear, and unambiguous methods to form 3D property units, as well as register rights, restrictions, and the responsibilities of 3D property. So to form the property units, the cadastral process requires that the involved actors exchange and share information between each other. So now I will present the details of our study. So here is the contents. First, introduce the current property formation process in Sweden by two articles, and briefly introduce the background of the BIM and BIM standard. And also I will describe our study methodology and the life cycle 3D property formation process. And we use the IDM process to explain how the data exchange and share among different actors during the 5 phases of 3D property formation process. And in the end, I will conclude our study and future research. So in Sweden, the cadastral authorities use 3D CAD drawings containing the 3D real property boundaries in the cadastral property formation process. But these drawings are not formally achieved in the National Real Property Register. And the organizations and different stakeholders involved in the 3D property formation process reveals it as an unclear and ambiguous process. So in the left figure, so Andrea presented the current 3D property formation process and developed a vision of a future where the different actors cooperate in conjunction with BIM and GIS, and soon formulate the general basic requirements for 3D cadastral formation and proposed a framework shown in the right figure, and to integrate the 3D cadastral and the 3D digital models, both the BIM and the 3D GIS, the CTGML. But no detailed description was present of the digital data delivery between the actors, as well as actions from the actors to obtain an unbroken digital flow of data in the 3D cadastral process. So the main difficulties and drawbacks are how the cadastral information should be shared and among the different stakeholders in the 3D property formation process. So we have many researchers have already introduced the BIM, and so I just want to mention one thing, that BIM is not only a model or tool, but also a process and technology. And the Building Smart has developed the international open standard. We know that is IFD, IDM, and IFC. And IFC is the most aspirated open international standard in the BIM domain, and it could support definition of building elements and the spatial relationship between the elements. So it has the power capability. So that is why many researchers use the IFC to integrate with Cadastre in order to represent legal spaces and the real property boundaries in the physical models. And another BIM open standard IDM is to capture and specify process and information flow during the life cycle of a facility by bringing many different stakeholders together in a project-specific organizations, and have many benefits. It could clarify detailed process, help all actors communication, harmonize different product data models delivered and stored, identify the results of that activity, as well as improve the management more efficiently and collaboratively. And another thing I want to introduce is the level of information need, the LON. It's a new standard of BIM, and it can be treated as the combination of level of detail and level of information. But actually, it's not a simple replacement for the load concept. The loan is intended for clients who define their information needs for project management. So within the loan concept, various the metrics can be used to measure the information to be delivered. In particular, the geometry, alphanumeric data, and the document for some example, like the unstructured information such as plans, reports, and photographs, and so on. And the alphanumeric information should be considered as important as geometry information. So in this study, we aim to facilitate a standardized and ambiguous digital 3D property formation procedure on a national level in order to enhance the digital Swedish cadastral and land administration system. So the proposed life cycle 3D property formation process is based on BIM and describe the cadastral data exchange and sharing in the process by IDM, and illustrated the task and the different actors. So according to the previous research, the 3D property formation could use the same process as for the formation of other property units, but adding specific rules and standards concerning the use of 3D. So it can be divided into 5 phases: the initiation phases, preparation and decision, registration, and update phases. So in our study, we use the BIM-based approach. So the loan are used to specify how the information is going to be delivered. And for example, like the purposes, we do use of cadastral information to be delivered in the BIM models. And another aspect is information delivery milestones, some of the geometry information, alphanumeric information, and documentation. And the third one is the actors. So who are going to request and who are going to deliver the information during the 3D property formation process. And the last one is objects, to organize in one or more breakdown structures, for example, like the IFC spaces. So these 4 aspects should be considered. And for that one, we proposed the IDM process. And here is the overview of the IDM process. Is a little small, maybe from the screen, and I will divide it and introduce phase by phase. So the Swedish real property formation is the responsibility of the national government. And based on that, we identify the 5 main actors when forming a 3D property. So applicant, the cadastral authority, local municipality, cadastral surveyors, land and the environment court. And we also use the to explain how the data exchange and share during the different actors. And the blue color shows the input data, and the black color shows the output data. So the process starts with the initiation phase when an applicant prepares and submits an application for property formation. And the applicant can access geodata model, plan model, and digital model, and others if they need. And then the application is prepared by the applicant, sent to the surveying authority, and supplemented early in the process with a digital property formation model. And the submitted model is a suggestion for the property formation and has no legal force. And the application is, after being received by the cadastral authority, moved to the preparation phase. So the data, the input data could be the IFC or BIM models, 3D geodata, or CAD drawings, and the output data in this phase should be the proposed property formation model, but without any legal force. And the second phase is the preparation. So S1 starts with the technical at the cadastral agency, checking the formal aspects of the submitted application. But if not accepted, then the application is returned to the applicant for the revision and the resubmission. And if accepted, then the application is assigned to a cadastral surveyor who is in charge of the entire property formation and the registration process. So the surveyor inspects the applicant's architectural plans and the necessary cadastral maps on footprint level, and reviews the suggested property boundaries and the need for rights, restrictions, and responsibilities in 3D by using the original information in the cadastral dossier. And if needed, the cadastral surveyor will consult with local municipality. At the same time, the work meetings and other contacts will be held continuously with the applicant. And this phase ends when the cadastral surveyor makes a preliminary registration of decision in the real property register. And in the decision phase, after the payment is settled, the cadastral surveyor will conclude the cadastral procedure and make a final decision. And both the applicant and the municipality will receive the decision information and decide whether to appeal to the Land and Environment Court or not. The decision includes a property formation model, 3D visualization, and appendices, which are stored in the 3D cadastral dossier. So the output, the data in the decision phase is the 3D cadastral dossiers. And in the registration phase, the cadastral surveyor will finalize the registration of the new real property unit after the mandatory appeal period has ended and no appeals have been made. And finally, the applicant will receive the formal property documents and the property formation process ends. So in the phase, the cadastral surveyor will update the new 3D property units in the 3D city model after registration. So if the city or municipality, they have the city model, and then they could update the 3D city model. Okay, finally, to conclude, we designed, developed a BIM-based 3D property formation process. And in this study, the loan has been used to specify information requirements according to the 3D property formation purposes. And IDM used to design a develop process of the Swedish 3D real property formation, and including the 5 actors and the data exchange flow. And this proposed methodology facilitates a standardized and unambiguous 3D property formation process and enhance the holistic cadastral management in 3D for the sustainable development. And for the further research, it's an ongoing research. So we will implement some more detailed about the exchange requirements of 3D property formation will be using by loan standards in the IFC models. And also we will implement some practical case study in the future studies. Okay, that's all. Thank you for your attention. Any questions?
Thank you, Jing. We are a little bit over time, but I hope the organizer will allow us few questions. And I see some here. First question, why is the process not modeled with UML activity and or use case diagrams? Do you think IDM is better?
No, actually, I don't think they have some the comparison. The UML could, like the LADM, it could be the conceptual database for the cadastral, and also the story, the cadastral legal information. And for this process, like the IDM of the BIM, this is because many researchers and our researchers, we will use the open international standard, the IFC, in our research. So if we use that in the BIM domain, the IDM is the open standard process. So that's why we use the IDM as to show to illustrate how the process of the cadastral info exchange and the story and also sharing the information through the different actors. So that is, yeah.
Thank you.
Yeah.
And next question, why IFC, IDM, and IFC so different ISO standard numbers have?
That question is, I think it's kind of because the BIM is a large domain, and the IFC is kind of like for the model, IDM is for the process, and we also in the BIM domain is also have the IFD for the definition. So they have so in the ISO standard, they have to use the different to explain how it could be used and for different usage and how to use that. So that's why they have so different ISO standard numbers. So, and also the loan, a new standard, is also just I think is published last year, but not finished right now. It's still ongoing.
Mm-hmm. There is also a question.
Yeah.
Leon
The next
is
question.
European standard. Why not ISO?
Yeah, it could be. Yeah, but because now it's still ongoing, and because it's a new proposal of the standard, and it kind of not the simple instead of or replacement for the current like the level of information or level of details of the in the BIM domain, not in the GIS domain. So it's kind of the new standard, but they still need more tests, and I think the criteria also need to thinking more about that. And also, so for now, not the ISO, but I think they are ongoing. Yeah.
Mm-hmm. And do you these property formation processes can be internationally standardized?
Yeah, actually it's hard to say because different countries, they have the different or the specific the legal or legalization rule, different law, the rules, and also they have different organizations, different actors. But we hope we could we try to create some of the general basic standardized process. So if the people or the actor, they use the BIM and as the physical model, and they could use the open standard process to illustrate to different actors how to form the 3D cadastral property during the formation process.
Mm-hmm. Maybe in a far future we will have procedures for all countries. Thank you, Jing, for your presentation and your answers. Now we are at the end of this session. Before I give word to organizers, I'd like only to thank you all for the attentions, and especially speakers for the nice presentations, and see you later. Peter, do you want to close the conference now?
Yeah, thank you, Miroslav. Yeah, I think the official closing will be in the session, which is later today, together with 3D Geomorpho. That is at 17:30 in New York time.
In 50 minutes.
In 50 minutes.
Yeah.
And in between, if you don't want to have a break, there's a panel discussion in track A, where also the closing and awards will be, on the different regional views on 3D geographic information. So that starts in 5 minutes, more or less, from now. Yeah, okay, some more personal words here in this session. Yeah, thanks everybody for the great contributions. You can think, okay, are we making any progress if you look back 10 years or 20 years? And I think we do, both in the practice, but also in the research. And yeah, these steps go little by little, some in a shock, sometimes gradually. Some countries go faster, others look and learn from the other countries. So it was great to see that here, and yeah, that was really in my mind today and the last couple of days, that we are really progressing our field in order to support, say, a society that can function well and that really needs this kind of three-dimensional representations to organize all the different activities conducted by the stakeholders, which are very important, like living, working, and so on. Thanks for everybody to also work with this online platform, which is not easy. For me, it is half the value of a conference. So I really miss the other half of the conference, the real meeting of people in the coffee break, seeing persons in person, and I really hope that we can have soon more real meetings. So I don't want to blame anybody on this situation. we cannot help it, but I'm really tired at looking at the screen after 10 hours or so, or maybe 16 hours, because in the morning you still work with your normal job, and then in the middle of the afternoon, evening, then the conference starts. So that's it. Really thanks a lot to the co-organizers, Eftychia, Alias, and the chairs, Miroslav, Efi, Jing, Jesper, and I forgot one. We had 5. What was I complete?
The first one.
Jesper?
Yes. Jacynthe.
Oh, Jacynthe. Yeah, of course, Jacynthe. Also, many thanks to Jacynthe.
But I would suggest, Peter, that those that we are here, we can open the cameras to have like a group photos.
Yeah,
Whatever
please
is good
open
for
your
you.
cameras. See what you are doing in this time of the
Very
day.
nice.
Really nice to make a big group photo. Let's see how many people fit on the screen here. We are now at 9 on my screen. And I'm not sure.
Yeah, and it would be nice if we
Nine.
don't leave and stay also
Oh.
for the closing ceremony, because we will have a best paper award there. It would be a pity if the winner will not appear.
Yeah,
You have
still.
an alarm clock because it's
Yeah.
It's late.
But anybody can be the winner, eh? Any author.
that's the
You don't
challenge.
want to miss that. Please, more cameras. I think they should be fitting more.
Yeah.
You made a screenshot, Eftychia?
I can make another one if you want to smile.
No. But can there not be more people, or is this all?
I can
Big
see
smile.
some more people there.
But they are really sleeping then, eh? If they
I
don't
have
open
been
the
taking
camera.
screenshots anyhow through the whole conference, but now to make it more official. Yeah, I took some for those that we are here. I took some.
Okay. See you later then, in the closing or in the discussion. I'm gonna have a little break.
Yeah. See
Bye.
you in a while. Bye.
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 Bye, everybody.